I found with disputes in the construction field, and partly because this from my own experience, having done it for so long, is that there is this tendency, this inclination in the industry to immediately defer to an adversarial approach to problem solving. Good example of that is the fact that in the 90s, because of the problems of this adversarial approach to resolving disputes in the construction sector, so the criticisms at the time were, expensive litigation, long drawn out litigation that effectively paid no attention to the fact that parties were often involved in the project on an ongoing basis and needed a quick way of resolving their problems. Legislation was introduced which brought in adjudication. Now, the idea behind adjudication was that would reduce the time it took to resolve disputes, maintain good relations on site, preserve business relationships going forward, and effectively provide a very normal kind of contractual route to resolving problems. Now, in my view, again based on my experience, it certainly reduced the time it took to resolve disputes. But did it take the heat out of disputes? Did it help to preserve relationships between the parties? Well, I'm not so sure about that. And what you ended up seeing actually over a period of time was a whole new industry developing around adjudication and how you deal with disputes through adjudication. Claims consultants, experts, lawyers, adjudicators, all specializing in this highly adversarial new way at the time of doing disputes, which was adjudication. So rather than actually taking the heat out of disputes, actually what adjudication often resulted in was actually more heat going into dispute resolution. Why? Because what people found was adjudication was a really, really tactical way of actually ambushing parties in terms of conflict resolution. Because it's such a short process that once you're in the process, you literally have no time to think or do anything else other than commit to the process. And it got to the point, and it has got to the point where actually now parties are probably spending just as much money, time, resources in this shortened adjudication process. 28 days, could be 56 days, it can be extended. But they're spending as much time and money dealing with disputes in that short period of time that they used to spend on normal litigation and arbitration. So the idea that this was going to help reduce costs and preserve relationships, in my experience, wasn't really borne out. So think about the benefits of mediation. So, for example, it provides an opportunity for the parties to take control of their dispute, keep control of their dispute, and find a resolution based on a negotiated settlement. So the power remains with the client. Also think about the fact that it's a way of actually bringing a lot of other issues into play, so that the dispute, so that the solution doesn't have to be on one issue. It can bring in lots of other issues, other related disputes that possibly would not normally be dealt with if it was just purely a judicial process dealing with a singular legal point. And one of the things about adjudication was the fact that you'd only ever adjudicate one issue at a time. I mean, that was one of the key points about adjudication. And obviously linked in with that is the longer term relationship that you're trying to preserve, as well as a short term relationship of allowing the project to continue. It's much easier to do that through a consensual process where you achieve a negotiated settlement, as opposed to something which is a decision imposed upon you, a decision which you may or may not like, or a decision that you may think actually is completely wrong in the circumstances, because adjudication is such a speedy process, a quick process, that often, parties felt pretty disappointed at the outcome, because it was just so far removed from what they were expecting would happen. And then also think about the fact that you've got a situation where mediation allows you to obviously keep control of costs, avoid expending too much management time and other resources in resolving the dispute, because mediation itself is a quick and, relatively speaking, compared to other processes, cheap process. And obviously you have the benefits of the confidentiality and the fact that whatever happens in mediation is without prejudice to any subsequent proceedings. So if you compare all of those attributes of mediation, compare that to the process of dispute resolution through adjudication, as well as normal litigation, they're at the opposite ends of the spectrum.